Hello, I'm WyoFile reporter Angus Thermer here to tell you about some breaking news regarding public access to public land in Wyoming. Just now, the U.S. 10th Circuit Court of Appeals has ruled in favor of 4 Missouri hunters who were sued by a wealthy landowner who claimed they trespassed on their way to public hunting grounds. Fred Eshelman, who owns the Elk Mountain Ranch in Wyoming's Carbon County, sued the 4 hunters in 2022, claiming they trespassed when they passed through the airspace above his property, sued them even though they never set foot on his land. The hunters reached their public hunting grounds by stepping from one piece of BLM land to another. The thing is that in southern Wyoming, a lot of this land is arranged public-private in a checkerboard pattern just like this. By going from one piece of public land, a white square, to another piece of public land, the hunters invariably had to pass through the airspace above Eshelman's private property, represented here by the black squares. That's a trespass, Eshelman said. There's 2.4 million acres of checkerboard land in Wyoming and about 8.3 million acres across the West. If Eshelman's trespass theory holds water, that means that those 8.3 million acres, those 2.4 million acres in Wyoming, is accessible only to the private landowner, even though it's public land. But the 10th Circuit Court of Appeals has just ruled that Eshelman's theory of trespass is wrong. The court sided with a federal U.S. judge in Wyoming who said that corner crossing in the checkerboard area of Wyoming is not trespassing. The court based its opinion on an 1885 law that Congress passed and that the U.S. Supreme Court has subsequently upheld in various interpretations. Read our developing story on WyoFile and also the follow-ups that we're going to publish. And as always, we welcome your comments.